to appear it as hearing in the month list of January. However, petitioner, there is no paper book at all nowadays, and all are indigent person, and out of 9 convicts minor, 5 are women and 1 is octogenarian lady, my lord.
What do you want?
My lord, for bail in connection with appeal, my lord.
Lord, may I?
Obliged, my lord, deeply obliged.
তখনও বেলের অ্যাপ্লিকেশন কোথায় গেছে?
আছে আছে
তখনও বেলের অ্যাপ্লিকেশন ছিল তো যখন মান্থলি টেস্ট জানুয়ারি অর্ডার হয়েছে?
তখন application ছিল, but it was not posted as bail in connection with appeal, my lord. Obliged, my lord.
Praying for your lordship's kind leave to lordship file an appeal without certified copy, lordship.
When was the order passed?
Lordship is 16 September, lordship. Lordship, that the petitioner was not well, lordship, unwell. She was unwell, lordship. She is a senior citizen, lordship. Lordship, that urgency in this matter is that, lordship, that today is the date, lordship, given by the CSC to install a meter in my premises, lordship, for a person who is no way related to me, lordship.
May I permitted to mention under compelling circumstances, my lord, I am mentioning this contempt application of this honorable bench, my lord. What happened, my lord? There was a deviation. Your lordships ultimately affirmed the order contempt petition for the, my lord, sanction, my lord, but what is, my lord, the deviated portion that has to be demolished. During contempt, my lord, there is a series of demolition program that happened. Lord, now, my lord, it's completed. What happened, my lord? My child, my lord, board examination is coming. If I want to make it, my lord, habitable, the corporation authority says I have to apply, my lord, to online for sanction plan. But since the contempt is there, my lord, I cannot even apply through online because OBPAS system will not allow. My client's board examination is there, my lord. If I cannot, my lord, my lord, make it habitable, my lord, I will have to, my lord, pursue my clients.
Submit it for the
Actually, private respondent says
your matter in the list.
No, my lord, that's why.
Just say you want it in the list.
Lord,
Why make argument?
No, my lord, since your lordship is taking up this contempt matter, my lord, only on Friday, that's why, my lord, I am. Since it is not, it is until and unless it's disposed of, I cannot even apply through online.
Why didn't you mention it over the last 4 days so that we could have it today?
Lord, I mentioned the matter. Lord, the matter was mentioned.
Sorry.
It was directed to appear on Friday.
Yes.
what happened, my lord, I am also appearing in the matter in the on behalf of
It will
corporation.
appear next Friday.
Corporation, my lord. Okay, man.
Regarding item number
Lord, may I hand over this slip?
regarding item number 86, under the next list, this is the admission of appeal.
86.
Fine. 86. The admission of appeal.
এই ভুল আছে দেখো
এই নিন। এই। Great.
May I be permitted to mention one matter? This is for relaxation of bail condition inclusion, but Monday I had mentioned file is in court, but still not listed. 10th of November I had already mentioned.
May I have your lordship's kind leave, my lord? My lord, praying for leave to file an appeal without the certified copy of the order, but with the server copy of the order passed by the learned judge.
When was the order
My
passed?
lord, May 7, 2025.
No, why should we grant you leave?
My lord, because my lord, this is in connection with the yesterday's matter that your lordship was hearing.
Doesn't
My lord,
matter.
this is, my lord, the appeal from the order whereby, my lord, we have been injuncted to form the association.
Do whatever you like. 27th May order. If you have chosen not to obtain certified copy, obtain and then file.
Your Lordship, kindly to mention a matter, Your Lordship, is an appeal regarding the hospital food tender, Your Lordship. So it's taken up on the 12th of November. Judgment was reserved. Lordship, Mr. Abhirtosh Majumdar and Mr. Rai Mukherjee were appearing for respondent 1 and 2. Their names have not been recorded in the last order, Your Lordship. Before I'm mentioning,
মুশকিল
this is the last order, Your Lordship.
কি খুলে করে দিতে পারবে না টু মেনশনটা আনতে হবে আবার নাম যায়নি
Have you submitted the appearance?
Yes, we have submitted your appearance. Mr. Majumdar, Mr. Rai Mukherjee for respondent 1 and 2 were present in.
শিখে দেয় তবুও কেন হয় না বলো তো এটা বলছে দিয়েছে
Lordship, it will appear as to be mentioned. Lordship, it appears to be
মেনশন দিতে বলো
gratefully, Lord.
Item number 1.
I'm appearing on behalf of the state.
Yes.
But I am appealing for the appellants. Well, there is probably a confusion created by the department. CRAN 3 is mentioned. Now, CRAN 2 is not mentioned. CRAN 3 and 2 both are different application for suspension of sentence.
Please,
What?
please.
Mala.
The department says it has not received any application marked as CRAN 2. CRAN 3 is there, that has been listed, but there is nothing like CRAN 2.
What
This is
has
the
been,
note, consider, do whatever you like.
what has been served upon as the cover letter says CRAN 2, but inside it says CRAN 3.
CRAN 2, malad, may I say, malad, CRAN 2 and 3, malad, the two different
Look at it, clear the confusion, ask your junior, and come back on Monday. Chalo. Look at the note and come back on Monday.
Very well.
Now, देखो, from a departmental note dated November 12, 2025, it appears that the TCR को लिख देना, the trial court records have been received by the department and the same is awaiting examination. Paragraph, let requisite number of paper books be filed by the department within 6 weeks from date. Paragraph, list the appeal under the appropriate heading. Now, let the appeal appear. Let the appeal appear. You're appearing?
For the statement.
Let the appeal appear in the monthly list of January 2026.
Item 3.
Only.
4.
তিন নম্বরটা
কেউ ছিল না।
16, 17, 18, 19, 20.
21.
Second call,
Second call.
20 yesterday, 20 yesterday.
20.
21, my lord. I am in 21.
6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20.
21, my lord. My lord, appeal against
21.
conviction, my lord.
No delay,
My lord?
no delay. Within time,
Yes, my lord.
usual order. Usual order. Not properly authenticated.
It's it. Correct.
Not properly authenticated.
Okay, certified to be true. Right. এটা না থাকে তাহলে কি হবে?
See, there is some defect. Remove the defect.
My lord.
You are admitting it.
My lord.
The learned advocate on record for the appellant is granted liberty to remove the defect noted by the stamp reporter. Stamp reporter by the section officer, by the department, by the look at it, look at that.
My lord, I am doing it right now. থাকে না।
দেখে নিন।
Nothing.
Uh, 22.
Lordship, in this matter, we are appearing. I am appearing for 2. Subrata Datto.
I am for item number 22.
22.
Please accommodation.
Right, there is accommodation.
On the request made by learned state advocate, let 22.
22.
Let this matter stand adjourned for the day.
Lordship.
You
Let me manually serve the BPFS.
Yes,
I am for another accused person, appellant.
In the same 22.
Same item.
22.
Yes. There are several petitioners, appellants.
2 grants.
No,
So there
9 years, above
there are-
9 years in custody, my lord. Above 9.
Kasmira Singh, Lordship, we are relying.
5 years in custody. What is the sentence?
My lord,
Life.
376D.
Oh.
My lord, that
Life imprisonment.
no, my lord.
Only 20 years terms imprisonment.
Fixed. When the term is fixed, my lord, then my lord, another judgment is made, my lord,
Lordship
by
to
the
bolte
Supreme
Lordship জানে।
You have spent only 25%. 1/4.
10 years.
10 years.
Approximately 10 years.
50% I have, my lord.
Come back on Monday.
Lordship.
CRAN 2 and CRAN 3, 2 applications.
Lordship.
Monday.
Monday.
High level.
23.
There are 2 applications that are being led by Mr. Shovik Mitter in this matter, my lord.
Last occasion, Your Lordship, called
Is
for
not
a
available.
report, Your Lordship, with regard to the medical condition.
Mr. Mitter is not available.
My lord is on.
I have the report, Your Lordship.
How long is custody?
My lord, he's in custody for 4 years and 8 months, my lord.
And what he has committed?
My lord, he's been convicted for offense under section 302, read with 149, my lord, and 326. My lord, there were 16 accused persons in this case. One of them has been enlarged on bail by this honorable court.
You have only
On my lord, 4 years, 8 months in custody as on date. Till 30 years the trial went on. He's a senior citizen at this stage. 3 witnesses had been relied upon while rejecting his prayer for bail.
My lord, may I take over, my lord? Report this.
So you are convicted. This is not a case under section 439.
Yes.
Then
Well, 389.
you are suffering from.
Huh.
You have to undergo the sentence. Then
Yes.
only 4 years.
4 years, 8 months.
So what?
SLP, no? Don't say SLP.
SLP dismissed.
Not SLP dismissed. Again, my lord, my order of bail in connection with appeal under 389 that stood dismissed. That was challenged in SLP, which the Supreme Court did not interfere. Now 4 years, 8 months have.
So what? You have to undergo 20 years or something like that. Then why 4 years?
I am on the issue of medical ground.
What is the wrong? What is the? Oh, there is no wrong in the.
My lord, first of all, I am addressing your lordship on the medical grounds.
Oh.
The man requires surgery.
So there is a.
He's 67 years of age.
Hospital is there.
The hospital has recommended itself.
After
The hospital has recommended.
what surgery?
Eye surgery.
I see is 2 hours.
No. He's visually impaired. Your lordship sees.
We've seen, I've seen. Yes, he requires optical surgery. That is the report. If he gives consent, he'll be sent to the eye department of Midnapur Medical College, because the outpatients department doesn't have that facility. Yes. What they say is that, yes, they agree that optical surgery, there is no provision in jail hospital. All patients are being sent to the eye department of Midnapur Medical College. And there is provision for optical surgery, but it is only done if the patient and his guardian gives consent. This is the report.
So, my lord, this is absolutely clear that man requires surgery, and this cannot be done performed in the jail. It has to be outside. Secondly, now your lordship considers he's 67 years of age, 4 years, 8 months in custody, requiring. I'm not for all the appellants, only one of them who requires.
What I am on that it is not under section 439.
So 389.
Conviction.
So 389, I cannot frame.
No, you have to show that there
Yes,
is
correct.
wrong
Absolutely, I bow down, my lord.
That is my.
Now, my lord, my lord, kindly cease. Now, what is the prosecution?
Arrange for your eye surgeon.
My lord, may I say the prosecution story? My lord, there are 3 angles to it.
One second. After conviction.
Post conviction, how much?
Post conviction, 4 years, 8 months.
Yes. So he is all along on bail.
All along on bail. Now, there are 3 angles your lordship sees. The first angle.
Sir, he was all along on bail, almost 5 years, close to 5 years. Kashmira Singh, 21 appeal. God knows when it will be heard. Let him go. 67 years old. Let him go. Stringent conditions will be there.
One person has been granted, suspended the sentence only because he was 80 years old. And his suspension of sentence was rejected. That went up to the Supreme Court, where the Supreme Court dismissed his.
Yes. Have you read your own report?
My lord. With regard to the medical ground, your lordship, I
yes, there are serious medical grounds.
My lord.
Issue. Medical report that we had called for has been filed by the state. Stop. Let the same be kept with the records. Paragraph. We find from the medical report that the applicant, petitioner, has serious health issues. Stop. The report also says that he needs to undergo optical surgery. Stop. There is no provision for such surgery in the jail hospital. Stop. He has to be sent to Midnapur Medical College, eye department. Stop. Paragraph, apart from health grounds, comma, we see that the petitioner is 67 years of age. Stop. He has already been in custody
For 4 months, 4 years, 8 months.
4 years, 8 months after his conviction. Stop. He was all along on bail during the trial. Stop. Nobody can say with any certainty when the appeal will be heard. Stop. Appeals filed much prior in point of time are yet to be heard. Stop. Paragraph. Learned State Council, comma, in response to our query, comma, has fairly stated that it is nobody's case that, fairly stated that there is no allegation that the petitioner jumped any condition of bail or misused the privilege of bail during trial. Stop. Paragraph. In the above facts and circumstances of the case,
one co-accused also on bail, but on grounds of age.
In the above facts and circumstances of the case, comma, considering that this appeal may not be heard in near future, and the petitioner has already been in custody for a long period of time, comma.
Kindly include the medical ground.
And we've recorded everything.
Otherwise, there are other 7 convicts.
And especially because of his medical needs, comma, we are inclined to allow this application.
Oblige.
Another application. But on the last occasion, your lordship recorded if none appears, that will be dismissed. But if your lordship kindly see CRAN 2, your lordship, this is CRAN 3.
Yours is CRAN 2.
3.
Yours is 3. It is CRAN 3 te holo, CRAN 2 te leko, CRAN 2 te now. On the last occasion, when this matter was called on, nobody appeared for the petitioner. Stop. Today also nobody appears. Paragraph. State is represented. Next, dismissed.
Satisfaction of CJM Paschim Midnapur.
CRAN 3 ta satisfaction of CJM Paschim.
Oblige.
বাড়ি কোথায়? বাড়িতে ওই থেকে বেরোবে না। Where does he live? Stay?
He stays in Paschim Mednipur.
পশ্চিম মেদিনীপুর। বেরোবে না। Without permission.
My lord,
report করবে once a month Ghatal police station.
My lord, permitted to mention that defect is that copy of the judgment given by the trial court is not in proper form. I undertake that I will today file the certified copy of the judgment afterward obtained, my lord.
We have granted that liberty. Do it.
My lord, 21 years I was on bail.
For the state.
2 years in custody after the conviction.
302.
302. My lord.
How many accused?
Well, there's one only. Oh, appellate. 8. My lord, 9 were there. One died in the jail, or rather in the correctional home. My lord, I'll tell lordship in the short form. I don't want to trouble your lordship with much. Date of incident and the FIR, which was recognized as an FIR, was after a period of 20 days. Now, in this case, there were
after a period of
20 days. Thereafter, my lord, what happened? The initial postmortem report, which was given, said that both these persons, husband and wife, died by suicide.
Two victims.
Husband and wife died by suicide. Committed suicide. Thereafter, my lord, after 72 days, right? After 72 days, the body was exhumed. Now, the body, when it was exhumed, it stated about One, there was some marks of strangulation. After 72 days, this is being found. And the other is suicide. So suicide was common in respect of the husband. If both the, but they never waited for a third PM report or some clarification or something of that sort. So my conviction under 3 and 2 for both the offences cannot lie. That's one. Second thing, man. Here,
How you are entangled? Both husband and wife died.
relative. Manat, what happened? The wife had an illicit connection with somebody.
Yes.
Right? Now that was the eyesore of the villagers and the relatives of the lady who died. As a consequence, the husband who died, he was an ex-police employee, or he remained as a police employee. Thereafter, when this reached its crescendo, then this happened that she was strangulated to death. If we take the 72 days later PM report on the skeleton of the body, and the other postmortem spoke about, as the inquest spoke about no injuries, it spoke about suicide. The postmortem report subsequently spoke about suicide. Now, my lord,
Yes. So you are saying it's quite possible that the husband killed the wife and then committed suicide?
Yes. This is my defense. Secondly, my lord, the most interesting part, well, I don't know, because my lord Justice Apurva Sinha Roy has done lots of sessions cases. My lord, I had stopped.
You did not do?
But in Assam, I did. Now, I tell Lordship, what is this? Now, my lord, first case in my practice, I've heard, there were total 15 witnesses, accused persons. Right? Now, out of them, 7 preferred a discharge. They were discharged. Once they were discharged, they became prosecution witnesses. And I don't know. I've never faced it. This is the first time I faced it.
So how you have been entangled?
Entangled. The statement of a child, the son and the daughter, who spoke about 12, 14 persons coming to the house in the night and then beating up both, killing both of them.
Beating?
Yes.
Identification?
No identification. Because she gave her statement 2 years after the date of occurrence.
She meaning the daughter?
Daughter. Both of them.
Daughter.
2 years after the incident took place. And she says that she was locked in a room and from a window, correct me if I'm wrong on facts, from a window she could see all this. First, no source of identification. Second, which is most important, there was no window in the house as per the statement of the investigating officer and
rough sketch map.
Pardon?
Rough sketch map.
Yes, there is no window. 22 years, I think I have entitled. It's a very good arguable case.
Mr. Basu?
My lord, what happened is that, my lord, this matter was fixed for hearing. We have even filed our respective written notes of arguments.
We are only on suspension now.
Yes.
Then my lord would kindly come to the depositions once of the son and daughter only, my lord, PW 7 and 9.
Yes, sure.
Paper book is there, page 33, my lord, and page 39.
Not annexed to the application.
No, it's here.
Paper book down.
In
PW?
Page 7 and 9. 1, volume 1.
7. Why,
Page
why
33.
delay 21 years of delay? Whether who caused the delay? In concluding
Judicial strictly.
only judicial, or they have taken time.
My
or
lord,
you
what
have
has
taken time?
happened, my lord, is that there were from different areas corruptions were involved. Certain police personnel were removed from investigation. Even the first post-mortem doctor against him, there was a departmental proceeding.
Which he won?
On the basis of that.
My lord, there were different things, my lord.
He came to the Honorable High Court. The High Court set aside that order. 21 years, my lord. The Lordship is of
21 years not in jail.
No, on bail. Well, the trial is a continuation of the
Yes.
Page 33, PW 7.
Yes, my lord. Please come. PW 780.
There are two page marks.
PW7.
Yes, my lord. My lord, at the last paragraph, suddenly,
Rojina Khatun.
Rojina Khan.
Yes, please.
He's the daughter, my lord.
আমি দেবো দেখ
What was her age at that time?
মানে 7
About 7 years old.
6 years.
No.
And then there is the brother also, my lord. First page, PW9, my lord. PW7, my lord. Suddenly we woke up, my lord would kindly see, hearing the hue and cry of my parents in night. We were about to come out of our room, but came to learn that the same was bolted from outside. Then my elder brother, PW9, opened the window, and both of us saw that Lal, Mala, Talu, Kasem, Kalo were being armed with lathi shabol. Seeing this, we started shouting, and then Kasem came there and pointed a gun towards our head and asked us to keep quiet, otherwise they would finish us. Out of fear, we kept mum. After a while, we could not hear the hue and cry from my parents anymore. We requested Kasem to open the door, and he stated that the same would be opened at time, and at dawn the said door was opened and we came out of the room, when we noticed that the portion of the body of my mother was hanging towards the courtyard and the half portion was lying on the veranda. Going nearer to my mother, I came to notice that the right portion of her face was covered with blood. Her tongue came out of her mouth. There was thick and black ligature mark around the throat of my mother. Her face was covered with a cloth and her body was covered with full of ants. Then I rushed to my father and came to see that my father was hanging in front of the kitchen room and there was a rope around his neck. There was thick and black mark on his back. The blood was clotted on his legs. We started crying seeing this condition, and then Kasem came there and threatened us not to disclose to anyone the facts that took place in the night. Otherwise, there would be dire consequences. Now, my lord, these are
Who lost the FIR?
Son. Sorry.
My lord, initially, perhaps, my lord, because
on the next day he filed the FIR, I think.
No,
my lord.
20 days after.
My lord, because initially there was another information.
What?
Because, my lord, this was filed by Muhammad Ali Malik. A complaint was filed.
Oh.
On the basis of this, the investigation.
What was the contents of the FIR in short? First FIR or Alim?
My
So you are
page
not
4 is there, my lord. I'll be placing that of the paper book, my lord. Petition of complaint is there. Complainant is son of Tajen Mollik. On last 28th of July at around 8 a.m. in the morning, 2 persons of the village came by a motorcycle and informed that brother-in-law of the complainant. Complaint.
Page, which page?
Page 4, my lord.
Mr. Vasu.
What charge, my lord?
Mr. Bharshaji, sorry.
Yes, my lord.
Mr. Mukherjee says that there was no window in the house.
IO has said it.
The specific deposition of this girl is that tried to open the door, bolted from outside. Then the brother opened the window. Through the window, she witnessed whatever she witnessed.
Yes.
If there is no window, then that makes a very, very big hole in the prosecution case.
And also, my lord, would kindly come to PW10 then once, my lord. An independent witness. Page 44 of the paper book.
No, we are not on the merits acquitting him.
No,
Yes,
very well,
just a question of bail.
If there are holes, and if he has been on bail for 21 years, that, according to me at least, is good enough.
My lord,
for
can
suspension.
any order. I will just be placing that.
Yes.
Then my lord can pass any page 44, my lord.
44.
Yes.
Who is this, Kaiser Ali?
Not of the same local villager.
Yes, sure.
My lord, page 44. I used to know Anwar Ali Mondol and his wife Mustura Bibi of village. Both of them are dead. In the afternoon, there took place a sudden family altercation in their family with Nurul Islam Mondol alias Kalo Mondol. After the Mukred Namaz at about 5 to 5, noticed Anwar Ali Mondol and his wife and his daughter were leaving their residence and locality. Then Kalo Mondol, Mala Mondol, Lal Mondol, Babu Mondol prevented them on the way by saying that it was evening so that they would not go away at that point of time, took them with them to their house. On the next day, I came to know that and his wife passed away in their residence. Having received the
State news.
yes, yes. Just
I had been to the.
my lord, I stand corrected. It's PW 11, my lord, page 46. I'm
No, take it, no problem.
page 46, my lord. Yes. I was returning home at 12 a.m. to 12:30 a.m. on 27th from our Diamond Club of village. I noticed Nurul Islam Mondol and Mala Mondol were roaming in front of the house, residence of Anwar Ali Mondol, being armed with lathi. When I came nearer to the house of Anwar, I heard hue and cry from inside the house of Anwar Ali Mondol. I then asked Nurul Islam Mondol, addressing Chacha ki hoyeche. Then Nurul Islam Mondol reported to me that they had got their own family dispute and asked me to leave the place. Mondol reported to me that they had gone to their own.
No,
When I took a few steps ahead by turning the road, I heard huge sound of crying from the house of Anwar Ali Mondol. Then I went to the southern side wall of the premises where there is a grill gate and noticed to the space of grill gate that 3 to 4 persons had pushed Anwar Ali Mondol and his wife Mostura Bibi against the earth of the veranda of the house. I also noticed that Kasem Mondol, Mannal Mondol, Soiful Mondol, being armed with lathi, were patrolling over the courtyard of the house. Being afraid of the situation, I fled away. On the Nirmala, their presence is there.
He doesn't name Lal.
Yes.
Where?
Malad, some are named. Maybe all have not been named, Millard. What he could see, some may have been inside. But I'm not going to justify him. What he has said, I'm just placing that, Millard. So the presence of the accused persons armed with lathi, he places that. He's an independent witness. Now, my lord, the son and the daughter.
Yes. Is there any contradiction of from the IO statement?
Yes. That's I was just waiting for him to finish.
PW?
16.
Whether he stated before the IO same thing during investigation.
Has been marked.
11, right? PW 16.
Page.
Well, it starts at page 55. 55. That's the first IO. I will rely on page 59. Third paragraph. It is true. 59 or third paragraph. ওইটা দেখাই হ্যাঁ ওইটা দেখাই তো হ্যাঁ No.
That's the house. Suicide 161.
My lord, with regard to PW 11 contradiction, page 62, my lord would kindly see. First, second, third.
Cross-examination.
We are not hearing the appeal.
My lord, fifth paragraph, my lord wanted to know the contradiction of the
Yes,
IO.
yes.
It is true that in his statement, PW 11 did not state under 161 that on the following date of the incident, when police came to the premises, Jahirul Islam took the police personnel with him to the house. It is also true he did not
Narrate.
he did not state that he narrated about the incident to his family members on the night. But with regard to what he has seen, there is no contradiction.
What is the witness number?
11.
Page 62 is the contradiction part, my lord, with regard to the cross-examination, with regard to PW 11.
And is deposing for the first time in court, man. Well, I leave it to your lordship. I can only say 21 years. I have a very good arguable case before your lordships because
Arguable case is there.
yes,
Issue.
Yes,
I'm grateful. Man. Thank you.
The petitioner
What happened?
has been convicted for commission of offence under section 302
I was really
APC and has been sentenced
how much junior
to suffer life imprisonment. He says that he is in custody for 2 years after conviction. Stop. For 21 years, i.e.
PW?
throughout
PW 7.
the trial, he was on bail. Stop. He has been falsely framed. They well, how many? And others, how many?
8.
Total 8, action mara gache 7.
7 before. They korbe shob petitioners.
Right.
They have been falsely framed. Stop. They have a highly arguable case for acquittal. Stop. They pray for suspension of sentence. Paragraph. Learned State Counsel, while opposing the prayer, takes us through some of the depositions of the prosecution witnesses. Stop. In particular, he relies on the deposition of the daughter of the victims being PW2,
7.
PW7 and PW11.
PW 10 is the son, and another witness, PW 11.
And
9 is the son.
PW10, that is the son of the victims, and PW11 being a co-villager.
Yes.
Stop. Paragraph. We have glanced through the depositions of the witnesses. Stop. There prima facie appears to be inconsistencies between the depositions of the various prosecution witnesses. Stop. For example, the PW7 being the daughter of the victims said that hearing hue and cry, she tried to open the door of the room where she was with her brother. Stop. Finding the door bolted from outside, her brother opened the window in the room, and then they witnessed the incident. Stop. However, PW, second investigating officer, PW 16. PW 16 being the second investigating officer, in his deposition says that the sketch map does not show any window in the room.
Location inconclusive.
Stop. There are other inconsistencies as well, and it cannot be said that the petitioners do not have any arguable case. Paragraph. We also take note of the fact that the petitioners have been were in bail throughout the trial for a long period of 21 years. Stop. It is not the state's case that the petitioners jumped any condition of bail or misused the privilege of bail in any manner. Paragraph. In view of the aforesaid and also seeing that there is very little possibility of early hearing of the appeal, we are inclined to allow this application. Condition
So, which court?
Bordhaman.
Paschim Bordhaman or Purbo Bordhaman? Purbo Bordhaman satisfaction of a CGM.
Kanla, so it will prove.
Kanla ACGM.
ACGM Kanla.
হ্যাঁ আর কালনা পিএসএ মিট করবে কোন সিনেমা আর ইউজুয়াল আছে
Grateful. I'm grateful.
মরে যাবে
26.
My lord, learned senior counsel, Mr. Chatterjee is appearing for the appellant. My lord, I'm praying for not today.
My lord, kindly fix the matter on Wednesday because my lord, my junior in this matter, my lord, his leg is
Hey.
fractured, my lord. That's why he has not come to
You
court.
broke
my
his leg.
Yes, my lord.
You broke his leg.
No, my lord, not me.
You have admitted.
No, not me, my lord. From accident happened, my lord.
Hey,
Yes, you said yes.
learned advocate for the petitioner seeks accommodation, paragraph, on the request of learned state advocate, comma, let this matter be listed again on Wednesday date to the other.
Fine. God bless, my lord.
27 and 28. Twenty-nine.
27, 28, I'm for the state, man. 27, 28, I'm for the state.
Yes,
I'm for the state. 27,
29, 20,
27, 28, I'm for the state, my lord. No one is appearing every day.
नहीं तो petitioner.
Every day, my lord, these matters are being
Oh,
called.
they were not here.
No one is
Lekho,
appearing.
lekho, lekho. On the last occasion, on the last day, when this matter was called, কিছু record করা আছে?
No.
নেই. When these matters were called on, comma, nobody appeared for the petitioners. So today also nobody appears. Paragraph. এই ক্র্যানগুলো খালি অ্যাপিলটা না খালি ক্র্যানগুলো ডিসমিসড give your appearance এই দেখো শোনো একটাই ক্র্যান আছে ওই প্রথম সিআর এটায় ক্র্যান 1 দ্বিতীয় অ্যাপিলটায় কোনো ক্র্যান নেই
ডিসমিস
এটা কম্পোজ হয়ে যাচ্ছে সিগন্যাল রিলিজ করতে হবে
27, 28.
29.
এটা কি হচ্ছে এই সামনে
Well, for the four of the petitioners,
Say before my learned friends submit, one report was called for.
Lordship had called for a report. That
I have
Lordship
received-
kindly sees the last order.
when will you get it
Say some more time because antecedents they are searching for 3-4 days. Wednesday.
Wednesday
My lord, in
Wednesday.
respect of the one of the appellant, my lord, not applicant, appellant, my lord, I have found, my lord, two cases. One is NDPS, another is, my lord, 307.
very well let the state file a report
So he's saying about it about an accused who is not before your lordship at present.
There are six appellants. There are six appellants. Four are
that
before
is
your
not
lordship.
relevant
So I'm not concerned about that.
देखो Mr. Shur, comma, learned state council
I have already cross-checked.
says that it will take a few more days for the state to produce the report that we had called for by our order dated November 7, 2025. Stop paragraph. As suggested by Mr. Shur, comma, let this matter be listed again on Wednesday date the other, comma, retaining its position.
Lord, grateful, my lord. I'm grateful.
Thirty.
Fiction under section 6 of the POCSO Act, 12 years imprisonment. Out of 12, 8 years, 5 months already served out. Throughout the, I'm only on this ground, I'm praying for bail.
What is the charge?
Well, he is a, he was staying near a tuition house.
What is the age of the victim? 12. And what was your age at that time?
About 35.
Oh,
No, 35, about 34.
32. Well, 20 years gap. We are here.
But full of contradiction, my lord, this all was set up by PW6.
So is
He's a teacher, taking tuition class. All the students were playing there. Some quarrel happened and they beat up the person. It's an arguable case, my lord.
Not whose conviction, but
Lordship kindly considers the medical evidence, PW7, PW6, who is the private tutor, and the nephew of PW6, 4, who is the friend of the child.
Serious allegation. And defect to contesting.
In the cross examination, when the appellate admitted his presence in the at the place of
But
That is not disputed.
at that relevant
but
point of
Kashmir Singh and Soudan Singh,
because my lord, in the coordinate bench appeal proceeded for hearing.
8.5
Then, my
years.
lord,
No, never.
change of
It
because
was running in the list.
it was
But we had prepared our notes for final argument and for the purpose of filing thereafter. But the grand application
No, it was never taken up for hearing. my lord.
was kept present.
That is the only thing. We are not on merits. And this is a 24 appeal. 19 appeals are still pending. Very sure. The applicant was convicted under section 4 or 6?
No, my lord, 6.
6.
POCSO 6 and 376
6
2I.
I.
Section 6 of the POCSO Act 2012 and section 376 bracketed 2 bracketed I IPC by learned judge, special court bracketed POCSO, Alipur, South 24 Parganas in special case bracketed POCSO bracket was number 143 of 2017 by judgment and order dated March 6, 2024 and stop. The applicant was sentenced to suffer rigorous imprisonment for
12 years.
Stop. Paragraph. The applicant's petitioner, which one applicant petitioner says that he is in custody since
8 year, more than 8 year, 4 months.
custody for more than 8 years, 4 months. Stop. He was all along in custody throughout the trial. All along Takitada. He was in custody throughout the trial. Stop. He has already served 8.5 years out of 12 years. Stop. There is no certainty as to when the appeal will be heard. Stop. Relying on the ratio of the decision in the case of Kashmir Singh, citation to the 1977 kiyache, the petitioner prays for suspension of sentence pending disposal of the appeal. Paragraph. Opposing the prayer, learned state counsel and learned advocate for the de facto complainant draw our attention to the deposition, the evidence on record. Evidence on record. Stop. They say that there is overwhelming evidence against the petitioner, which clearly shows his guilt. Paragraph. We have considered the facts and circumstances of the case. Stop.
2 of 24, which is also praying for the same relief, my lord.
Yes, CRAN 2 of 24 and CRAN
And then CRAN 1 of 2025.
Are you aware?
But I am not aware. This is a change. Then I'll not press it. I will press CRAN 2 24 because we are asking for bail. So if your lordship
So
kindly take
you decide which one you will.
no, the first one I will pray. Definitely,
Not press. First one.
First one I will pray. This one I will not press. Sharuti is the mother and Radhika. This is CRAN 3. CRAN 2.
Amaka to CRAN 1 ache dekho.
CRAN 3 of 25.
Yes, I have filed it.
Lord, I am appearing for CRAN 1 of 25.
CRAN 2 is not the same applicant.
So
the same.
Addition, Amit is also there.
Omor. But if your lordship takes up the entire issue, it's a very short matter.
So CRAN 2 is not pressed.
CRAN 2 is not pressed.
So Amor Kirtaniya's prayer is not
Yes,
pressed.
not pressed. He is not in a position to get bail. He is the assailant. He killed that victim with the axe. I am the mother and the daughter.
What is there to show that you also represent Amor? That you are not pressing.
My lord.
You authorize not to press.
Yes, I have filed the Vakaratnama for Omor also.
Filed for Amor?
Yes, but I have taken no objection from the erstwhile advocate. So, I appear for 3.
You have power from Amor, Sharuti and Radhika.
Yes.
Very well then.
I am not pressing it.
CRAN 2 টাকে করে দাও তো CRAN 2 of 2020 করো
24 টা not pressed.
This application for suspension of
করবে তো
was taken out by Amor Kirtaniya
My lord বলছে তো
and paragraph. Mr. Anjul Bhattacharya from a learned counsel appearing for the applicant petitioners says that he is not pressing this application and he is authorized to appear on behalf of all the 3 petitions. Paragraph CRAN 24 of this district.
There is one CRAN 3 also. ওটা জানতে হবে।
So whether you have an instruction for not pressing the.
I don't have the instruction to withdraw the petition. I need instruction, but not to press it. But I being the advocate of the court, I can do it. I'm not CRAN 3. I don't have any copy on CRAN 3.
Even we are not aware of CRAN 3, my lord.
CRAN 3 কি আছে? May I?
Not press করে দিয়েছি।
Paper book direction may also kindly be given.
Go through fast.
Paper book is.
Give me 1 minute time. I'll go through it.
Paper book has been served on the state.
Yes. I have taken the. But may I get a copy?
Departmental note. Yes, of
may
course.
I see for 1 minute? Within
I don't know who has received. Both of us are appearing for the state. We did not receive.
That's the departmental note. Look at it.
Department. Then, my lord, we have to find out in the department.
No. It has been served on state advocate. That is the note.
কে নিয়েছে একবার দেখতে হবে। Who has received it? না কে নিয়েছে? State level.
Find out somebody has taken.
My lord. Because we are 3 sets of lawyers for the state.
CRAN 3 টা কোথায় আছে? এটা বার করে দিন না।
CRAN 3 is the first CRAN.
সেটা তো আমি ফাইল করেছি। CRAN 3 has been filed by me.
Yes, Sharuti and Radhika.
Yes. I'm pressing it. Yes.
But then what is 1, my lord?
This should be
we have 1. Kindly have a look, my lord.
There is no 1 in the list.
CRAN 3.
My lord ke dekhan.
Wrongly it has been written. It will be CRAN 3.
There are 3 applications. 3 state councils have been appointed. That is the only.
CRAN. I tell you, lordship, CRAN 2
এটা কি পড়ে গেছে?
Was the first bail application. CRAN 3 has been filed by me. It has been wrongly mentioned CRAN 1.
Yes, this is probably CRAN 3.
CRAN 1.
You have CRAN 3 with you?
Yes.
May I come back on Monday, my lord?
বাবা পড়ে দাও না কেন
There is only one difficulty, my lord. I am prepared with the matter. The difficulty is that the pagination which I have got the notes is not tallying
during
right.
vacation the same thing happened. Well, he was not ready.
How long you are in custody?
Well, more than 20 months. Well, that is not the case. Kindly seize my involvement for 1 minute. But I will.
Asking for a day's accommodation.
Well, every day, I was waiting for yesterday day, today also.
Under number one item, under the same heading.
In the
Well, it will not take more than 2 minutes of my lord.
Don't have a problem.
পড়ে দাও না বাবা কেন করছো মানে আমি করবে
The only difficulty is with the pagination. If your lordship may kindly bear with me.
I will place it.
Then
What pagination? What pagination?
well, supposedly if I mention some pages, my lord, that is not tallying with of my record. My brief.
Well,
my learned friend will help me, my lord. My senior.
Absolutely, absolutely. Well, it's a matter, where my brother, hit the victim who died.
Don't say my brother. You are Sharuthi.
Sharuthi is the mother. Sharuthi is the mother, and Omor is the assailant. Is Radhika's brother and Sharuthi's son. Now, the incident happened on 22nd. Victim's name is Fulmala. Related. Well, they are neighbors and they are related. But there was a dispute of regarding land dispute. But the incident happened on 27th of February 2023. On that day, Omor hit Fulmala with axe, and she expired on the spot. Radhika was not present, was not there at all. She came to her matrimonial house 1 day prior. What is the role of Sharuthi? Sharuthi is
to the matrimonial house.
sorry, her parental house. Her parental house 1 day prior of the incident. 26th she came, 27th the murder took place. Now the situation is, the Sharuthi was present. The only word she has used is, in front of Sharuthi the murder took place. There were 4 eyewitnesses. Everybody has mentioned in the deposition that Omor hit the victim and the victim died on spot. Now
you were on bail during trial?
Absolutely. We are taken into page 86.
Here, Omor is the assailant as per FIR.
Lord, as per FIR,
And instigation is from such and such.
They are the main instigators, my lord. She could have survived, my lord, because what happened, my lord, from the depositions, what we could find out, that once Amar hit her, then these appellants, my lord, they came and they said, oh, she is still alive, hit her.
Oh, who was the eyewitnesses?
Eyewitnesses,
So why
2, 3, 4.
Why eyewitnesses did not register them?
My lord,
Why the eyewitnesses did not
Lord, if someone has an axe in his hand, and the eyewitness of a village, my lord, they could not muster the courage to go and intercept a person who is on a killing spree.
It is your FIR that
FIR is not an encyclopedia, my lord.
Okay, I understand little on that point of law. Omor Kirtania and Sharuthi are cutting the mango tree surreptitiously, not in presence of other witnesses. That is the main thing.
My lord, I bow down, my lord. At the time of cutting the mango tree, it was surreptitiously.
Yes.
But when the attack on the victim happened, my lord, then certainly the crowd swelled up.
We are not granting bail to Omor.
Amar he has not pressed, my lord. Amar is not before your lordship. My lord, Radhika, I leave it to your lordship, my lord. Kindly have a look at PW4.
67 years old and 45 years old.
I bowed on, my lord.
Right? They were all along on bail.
My lord.
It is not your case that they misuse the privilege of bail.
Sarthi was not on bail. Only Radhika was on bail.
Sharuthi said you were all along on bail.
Kindly see the order 86. They were taken into custody. Page 86.
The same thing. She remained custody for a long time. That is also a ground.
I bow down. I leave it to your lordship, Lord. I will not stand in the way if your lordship has formed an opinion. But, my lord, I beseech your lordship, kindly have a look at the deposition of PW 3 and 4 before your lordship may pass necessary.
Why is the deposition?
2 and 3. Where is it? Page 20 of the judgment. Oh, that is the extracts of the deposition. So we don't have the paper book, my lord. We don't have the paper book.
So we are inclined to allow the.
I bow down, my lord. I leave it to you. I bow down.
The learned counsel for the petitioner has submitted that he already got pressed bail prayer of the principal accused Amor Kirtonia. Now, stop. Now uh, he is praying for bail of the two female accused, namely Sarothi and
Sarothi Kirtuni and Radhika Sarkar.
on the grounds that they are not the principal accused. The allegation against them that they instigated the principal accused Amor to assault on the victim. Stop. However, the petitioner Sarothi was all along in custody.
Yes, Sharthi was in custody.
Was all along in custody during trial, and he is aged about 67 years. Stop. Sarothi and another petitioner, namely
Radhika.
Radhika Sarkar, was in custody.
No. Radhika was on bail.
Radhika was on bail.
Was in custody for 20 months after conviction. Stop. As they are not the principal accused, and as there is no chance of an early hearing of the present appeal, he prays for bail of the two accused persons, two petitioners, namely such and such. Stop. The learned counsel for the state opposes the prayer strongly. According to him, the present petitioner instigated Amor Kirtonia to assault victim with the help of with sharp-cutting instrument. Stop. There were eyewitnesses who confirmed such instigation from the side of the present petitioner. Stop. We have considered the materials on record, including the evidences, and find that the principal accused is Amor Kirtonia, whose bail prayer has been not pressed today by the learned counsel. Stop.
In CRAN ওটা বলে দিন
CRAN number such and such.
এটা CRAN 3 লিখবো
And the petitioner Sarothi is aged about 67 years, and she was all along in custody since the commencement of the trial. Since the inception of the case. Stop. There is no chance of an early hearing of the present appeal. In view of the above, we are inclined to allow prayer for bail on certain conditions. বলে দেবেন, কিন্তু এটা কিন্তু কোথাও মিট করবে। ঠিক আছে?
At SCGM Bonga.
SCGM Bonga. And what is the Radhika Sarkar's
residence? Kindly give me 1 second.
Radhika Sarkar shall not leave the district of Nadia excepting for the purpose of attending court. No, yes, Sarothi hota 20, not 24 program. Shall not leave for 24 program. It is Sarothi, petitioner number 3. Sarothi justice. Okay. Shall attend the court as a police station এ যাবে না। ঠিক আছে? Okay. All our conditions. The NDPS. NDPS.
33 to 35.
I place one judgment before your lordship that the contraband goods was not produced before the court and the punch witness, means independent witness, didn't support the prosecution case. On that, Honorable Apex Court set aside the conviction.
See,
Paragraph. Contraband was never produced in court.
33. Lordship is taking up 33.
These items.
I am in 34.
Who is in 33 for the state?
Malada.
Yes.
My lord, I am in 34.
I am showing to you.
No, have you seen this judgment, please?
Lordship will kindly comes to paragraph 24. Paragraph 12 first. Sorry. Lordship has got it. We are thus of the view that the prosecution has not produced the brown sugar before the court and also not offered any explanation for non-production of brown sugar alleged to have been seized from the appellants, and as the evidence of the witness PW2 and 3 to the seizure of the material does not establish the seizure of brown sugar from the possession of the appellants. The judgments of the trial court convicting the appellants and the judgments of the High Court maintaining the convictions are not sustainable. Very well, my lord. Lordship has got it. Your lordship will kindly comes to. Your lordship has the paper book with your lordship. Paper book. Yes. So, I have the paper book.
My lord, brown sugar is not your contraband article is not produced.
Not produced.
Sample is not produced.
Sample is
My lord,
So enter.
Lord, I will come. My lord,
Exactly, my lord.
I am coming to all
That
everything.
is the law.
They have argued. They have produced this judgment. They have argued. Now your lordship will kindly comes to PW8, that is page 26.
Was the seizure established?
Yes.
Independent Caesar witness declared hostile.
Now that is different.
Same case as Vijay Jain. Vijay Jain also, the independent witness.
This is not the. What can I say?
What if you lordship see the Vijay Jain, they are also only
Whether representative sample was produced or.
Lordship will kindly takes paragraph page 26.
Because 52A says that the entire consignment is required to be destroyed.
For that,
My lord, for that inventory certificate has to be there.
Yes.
That is
That
certificate in the judgment. Your lordship will find.
So you.
That is only 2 lines I will show it to your lordship regarding their grounds. What they have taken.
Yes.
26.
Now your lordship will kindly comes to inner page 29.
Inner page 29.
Running page 29. Sorry. Your lordship will find in the middle from the bottom. The word starts from sample. Sample was produced before this court and the seized contraband was produced before the magistrate for inventory.
Where?
From the bottom, sample.
Sample was produced before this court and the seized contraband produced. How is the matte exhibit?
Now your lordship will kindly comes to page 32.
32. Material exhibit.
Cross-examination on behalf of the accused.
I do not know. You have to produce.
Page 88 of
Kindly
the
seize.
The list is given.
Kindly seize once.
32.
In page 32, running page 32.
Running page 32.
Cross-examination, the first line. In the certification by the learned magistrate, it is mentioned total quantity of 549.25.
Oral evidence.
Well, Lord, there was a certification.
No.
Post inventory, there was a certification. Well, Lord, that we think that is exhibit. I think 18 to 20. It will fall under that.
Shall find.
Page. That is what I am submitting. Kindly come to page 86. No, I am on behalf, his behalf, I am placing the exhibit list prepared by the learned judge.
You did not help us.
Yes. Exhibit, please.
Lord, kindly seize the matte exhibit
10 and 18.
10 and 18.
Why we shall find?
My lord,
original.
Page 88 of the paper book, or your lordship can also see.
How can document be matte exhibit?
Exhibit number?
Lordship, exhibit 10. And thereafter 18.
And it will come under thing, my lord, section D, material objects. It is,
Yes.
I think,
Yes,
Matt
Matt
Exhibit
Exhibit, I
7.
know. Exhibit 7 certified copy of GD.
My lord, 88, serial D.
18 হচ্ছে
Serial D.
Matt Exhibit.
Material objects.
Yes, what is the number? Matt Exhibit 1.
Matt Exhibit 7. Serial number 3.
কোথায় পাচ্ছি না, এটা খুঁজে দিতে বলুন তো। এটা খুঁজে দিতে বলুন তো।
হ্যাঁ, এলচিআর ম্যাটার ওটা তো ইনভেন্টরি
ইনভেন্টরি রিপোর্ট এক্সিবিট 8
ওটা পুলিশের ইনভেন্টরিটা। হ্যাঁ, এটা তো
দাদা
পুলিশের
18
না,
আর 18 হচ্ছে ইনভেন্টরি রিপোর্ট।
ম্যাজিস্ট্রেট করেছে।
tell me by which witness it has been exhibited. By who exhibited this Matt exhibit? We shall go through the deposition. We shall find. And here.
This is the certification report. Now,
pertain to certain such. Yes.
ফটোগ্রাফটা কত এক্সিবিট?
Certificate 18. Exhibit 8. Certificate is there.
and the photographs is Matt Exhibit 10. Serial number 8 of the material objects.
Certificate is there.
That is the certificate of inventory. In this Vijay Jain also, inventory was there.
Then 52A rule 4 or subsection 4.
That has
What
to
is
be
it?
destroyed.
We have to take this
Destroyed.
certificate.
For that destruction certificate is required.
Okay.
But no, it is not the prosecution case that it was destroyed and destruction certificate was not executed.
There is a destruction
sample
certificate
seized
also.
articles was not produced.
No.
Sample seized articles were not produced.
Only no, sample was produced.
So you, according to you, entire seized
That is
articles.
what the Vijay Jain is saying. The entire,
But if this
That certification will not go, my lord, because my lord, let me finish.
allow me to put my question.
52 judge.
It will help you. According to 52A, that it is not possible to keep entire consignment or something like that. It has to be destroyed, for which some sample is taken in presence of magistrate, and that has to be certified by the magistrate. So entire
what is the destruction? If lordship see 52A, then there has to be entire completion of 52A. There must be a destruction certificate.
My lord, there is a destruction certificate also.
Where
My lord,
it is?
may I say?
yes,
May I
now Mr. Mittal.
Now, what is 52A? First of all, let us understand. 52A force requires, this is what the Supreme Court is saying, that there is a seizure. The police,
What is the seizure here in this case?
549 kilos of ganja.
Only.
Of
525 kg. 525 kg.
Sorry, 520. My lord, there is a seizure, right? My lord, the articles are taken to the police station, kept in safe custody. The list can be prepared, which is called the inventory list by the police. But that is, Supreme Court says, not compliance of 52A. Now, what is 52A? After that, the police makes an application for the magistrate. Requires the magistrate to allow that application. And now, after that, the sample is taken from that. And that sample only is to be sent for chemical analysis.
Yes.
Right? Then only if that is found to be ganja, heroin, whatever contraband, then only it will be deemed that the sample, so the quantity so seized is a contraband. This is first. The second part is, if that inventory certificate is present, then the mother quantity can be destroyed and that certificate can be produced in court, which will be taken as primary evidence under section 52A4, right? Now here, the certificate they are showing is of 11th of August 2021, after FSL had been done. Right? So, what was sent on FSL?
How long you are in custody?
4 years,
4.5 years. Now, what was sent to the FSL, inventory of the police, which they are showing. Now, these are the documents, kindly see. Now, এইখানে incident is of 23rd May. Police takes out the samples from the mother quantity, sends them to FSL, FSL, etc. complete. Suddenly they come, remember that no, 52 has to be complied. FSL report is already there by that time. Now, next page. In August, inventory is conducted before a magistrate. Mother quantity not produced in court. How is seizure established?
Lordship, kindly, we want to hear the appeal right now.
Lordship, kindly come to page
We want to hear
30.
the appeal right now.
We are ready. We are ready.
Let us
Yes,
understand that we are hearing the appeal.
My lord.
Start. Who will
My
start?
I-
Only one person.
My lord, three appellants, all three
Who
will
is
get.
senior?
Yeah.
So you will start and
My lord, let us turn to page.
You are not ready today.
no, we will take
That-
this argument.
Anyway, 12:30, there's another matter fixed. So
Start.
it won't end today.
If your lordship so desires to hear out the appeal, your lordship can fix up a date.
Better, because if they are only on 52A, if they succeed on 52A, the appeal will be allowed.
And this is a very good ground. I am going to dispose of
Only now it can be done. Now.
Only come
subject
to
to
page
corrections,
32 of the paper book.
subject to corrections with all my learned brothers appearing that side. Well, there are pictures over
There are
there.
Mohanlal's case. Mohanlal case that not before sending the seized item to CFSL, this has to be done.
Done.
That is the law.
Right.
And Honorable Justice Jaimallo Bagchi in a coordinate bench has also
That is why
decided.
I submitted. Only come to page 32, only one
I have,
line.
so appeal is complete.
Appeal is over.
Next day you will hear it.
Well, the only thing which they are relying on, if your lordship will kindly see, the only thing is inventory, when it was done prior to FSL or before FSL, that is their question. My lord will kindly see the IO is over here. He has pointed out there are material exhibits of pictures, which shows that when
Now,
it was produced before the learned magistrate.
Whether there is manipulation or not.
No, my lord, it was produced before the learned magistrate. Pictures are there of production. That is there in the MAT exhibit list.
When?
My lord, before FSL, after the contraband was seized, my lord will kindly give me the material.
How can that be produced?
আমি দেখাচ্ছি।
Inventory can only be done before a magistrate. And inventory is in August. FSL is in May, June.
Mr. Bishop,
I will.
Where is the certified copy?
I will
come back. You come back.
Parku.
We are hearing the appeal.
তুমি তো অ্যাপিল বেল বেলের জন্য
Appeal and
চলো নাও
এসছো। হঠাৎ করে মাইন্ড চেঞ্জ করলে হবে।
My lord is saying. Told me to order.
One day's time I'll do it.
Otherwise, we have to grant bail. That is the only problem.
I'll do it. I'll do it. Lordship will kindly gives me 2 days time. I'll do it.
We are ready with Mohanlal, Makilal.
একসঙ্গে হচ্ছে তোমার 33, 34, 35 together. Actually.
Only one person will argue.
After hearing learned counsel for the parties on the applications for suspension of sentence for some time alada kotha, comma, we have decided to hear out the 3 appeals. So,
What for chemical?
paragraph. We have heard learned counsel for the appellants.
দেখাতে চাইছি।
Today there is no more time. Stop.
This will solve the
Paragraph
issue.
lists the matters once again.
Kindly
Monday, Tuesday. Hey, Mr. Vishwas.
My lord.
When? Monday, Tuesday,
My lord, Monday.
Tuesday.
I send the sample.
I send sample with us.
From the
Tuesday date though. Huh?
over. Appeal over.
Sometimes you have
Tuesday fixed it.
sometimes you have to come this year. No?
Yes, my lord. I am always on that side. Sometimes on this side.
Under the heading specially fixed matters, marked
ভাই আমার 13 appeal fees. My lord, on Wednesday. My lord, Wednesday, my lord. Please on Wednesday.
Wednesday কি
Tuesday I
আছে?
have a matter fixed in 13.
Second half এর কখন 3:30 সময় প্রস্তাবে ফাঁকা আছে কেউ তো ওয়েডনেসডে ডেট দাও হ্যাঁ মার্কড 12:30 PM.
So you have completed your submission. Okay? You can give those
Judgments. My lord,
judgments.
judgment.
Give the judgments and only reply if you want to. Now we will look at.
Only, I'll point out the dates and give the judgment on which day what was done. Only the dates.
Small list of dates.
Short
List of dates.
I have prepared.
Well, I'll try to distinguish Mohanlal also. Well, paragraph 20 of Mohanlal, the amicus curiae's argument was taken into consideration. How
distinguish করে দিবি
না না মোহনলালের ভেতরে কিছুটা ডিস্টিংগুইশ করেছে মানে আমি ওটা
একটা পেপার বুক আমার
I'll come back with you.
তাহলে সুপ্রিম কোর্টে
দা উপরেরটা
ডাকো।
উপরেরটাই আমার হবে
আর এটা ডাকো।
নাড়াচাড়া আছে হ্যাঁ
এটা হয়ে যাবে
ও না এটা অনলি ফর জাজেস কপি হ্যাঁ এটা আমার
এটা আমার
$36 to $37.
Well, here I am in custody as of
I am in item 36 for this state.
only 30
as
36.
37
36. Bail I pray for bail in 36.
No, 37. Who is appearing for?
All bail allowed.
Oh,
But
37.
in that the
37. There is no crime.
no crime because all of them are on bail. 4 persons have been convicted. 3 are on bail. I am in custody for 5 years and 3 months out of 10 years. The distinguishing factor is
What is
that,
the offense?
well, NDPS.
NDPS.
Right. 10 years, I am already 5 years, 3 months. Now,
The others are on bail.
others on bail.
Suspension of sentence.
Yes.
Suspension.
Yes. My lord, they were in custody for 8 years, 7 years. They were granted bail. I am in custody for 5 years, 3 months because
because you absconded.
No, they were a custody trial for them. For me, I was granted bail on medical grounds. I suffered cerebral hemorrhage. This is the order. Now, they are on bail. After the conviction, I am in jail 5 years, 3 months.
So section 37 is there.
5 years, 3 months, my lord.
That is
Article 21 and medical ground. I am in jail hospital.
Post conviction.
Nothing.
5 years.
Post
conviction.
Post conviction.
Mr.
Bail.
My lord, in there, my lord,
How is he differently situated?
my lord, only one point, my lord, recovery, my lord, in his case is 300 gram, in their case was 100 gram, and my lord, they suffered 8 years, and my lord, this petitioner is 5 years.
That's nothing.
Because
that
I
is-
was on
Of heroin.
My lord,
Commercial quantity is 50.
250.
Oh,
my lord,
Joint seizure. Joint seizure.
my lord, from there, my lord, there is, my lord, from his personal, my lord, pocket, 300 gram was recovered. And my lord, from other individuals, 100 gram each.
So this body search was done in presence of gazetted officer.
My lord, independent witness is also there. My lord, kindly see page 41, my lord.
Okay.
The independent witness, my lord, deposition.
Four accused persons were convicted for commission of offence under section 21.
C.
Bracket, it's big C or small c?
Small c.
Choto c of the NDP Narcotics and Psychotropic Act 1985. And were sentenced to suffer rigorous imprisonment for 10 years. Stop. This was by a judgment and order dated June 26, 2024, passed by the learned additional sessions judge from a special court, bracket NDPS Act, bracket closed, Alipur, South 24 Parganas, in ST 04, bracket 01, bracket closed 19, SC 02, bracket 02, bracket closed 18. Stop. Paragraph. Learned advocate for the petitioner says that the other three convicted persons have been granted bail by a coordinate bench on the consideration that they were already in custody for 8 years. Stop. The petitioner is in custody for 5 years, 8 months.
3 months.
5 years, 3 months. Stop. This period is less than the other convicts because during the trial, the petitioner was granted bail on medical grounds. Stop. The medical issues still continues.
Yes.
Stop. Hence, the petitioner prays for suspension of sentence. Paragraph. Learned state advocate, while opposing the prayer, says that 300 grams of heroin was recovered from the pocket, from the petitioner's pocket. Petitioner's pocket. Stop. Stop. That being a commercial quantity, the restrictions in section 37 of the NDPS Act would apply. Paragraph. We have considered the facts and circumstances of the case. Stop. We see that the petitioner has already served more than half of the sentence that was handed up to him. Stop. The appeal is of 2024. Stop. There is very little likelihood of the appeal being heard on an early date. Stop. Appeals filed much prior in point of time are yet to be heard. Paragraph. Considering the above facts and circumstances and the importance of a citizen's right to liberty as enshrined in Article 21 of the Constitution of India, which must override all other considerations, including the What he can say is you acquitted হবে না কি ট্রায়ালটাই দিতে পারছি না ওইখানে রাইট টু লিবার্টি এন্ড স্পিডি ট্রায়াল করে দেবে স্পিডি ট্রায়াল কি বললাম including the restrictions in section 37 of the NDPS Act, we, without touching the merits of the case, and keeping in mind the ratio of the decision in Kashmira Singh. জানো তুমি এটা 1977 দিয়ে দিল, we feel impelled to allow this application for bail.
But only one indulgence, my lord, one line may be added, my lord, from the other 3 co-accused who were granted bail, from their possession, my lord, only 100 gram each was recovered, that is below commercial quantity.
That would be relevant if we were granting bail on the ground of parity. We are not.
ইকবালপুর পিএসএ দেখা করবে
condition আছে না
ইকবালপুর পিএসএ দেখা করবে
once in
a month.
CJ Malik
cannot once in a fortnight. Once in a
fortnight.
CJ Malipur.
CJ Malipur have a satisfaction. Okay. Once in a fortnight and shall not leave the local limits, limits of Kolkata.
Municipal limits.
Save and except for the purpose of treatment. Because he is suffering from that cerebral stroke. Save and except for treatment with permission of the court.
With permission of
the court. Of the learned trial court.
Permission of learned trial court. Chalo.
Obliged.
এবার ডাকো 12:30 matters.
Release for the day, excepting the 12:30.
Mr. Dev, the 12:30 matter will carry on till recess?
Yes.
Yes, released.
Happy weekend.
And to you.
He's always happy.
12:30 fixed matter, item number 80. Well, we were only required to file a supplementary affidavit that leave Mr. Mukherjee had taken the last day, because one supplementary affidavit relied in course of the hearing of the writ petition that was not forming part of the records. So Lordship permitted us, we have served them also.
Hey, yeah. Yes, Mr. Dev.
Lord, I am appealing for the appellant in this matter. I am appealing for the appellant in this matter, my lord. Now, my lord, the brief facts of the case, I'll just mention in a nutshell. Now, what happened, my lord, the government of Mizoram was the owner of a particular land in Baliganj area, 24 Old Baliganj Road. This was purchased in the year 1973. And thereafter, a guest house was constructed in that particular land. The land measured around 26 katha.
This is not that Mizoram house, is it?
Mizoram house, madam. Mizoram house. Old Baliganj Road. Now, that was the oldest Mizoram house in Calcutta, where the officials, patients, and everybody had to stay here. Because at that time, my lord, the only gateway of Mizoram and the entire northeast was Calcutta. So this continued for a long time, until and unless two other Mizoram houses were constructed, one in Salt Lake and one in Newtown, which were basically for the accommodation of the senior officials. Now, my lord, what happened sometime in the year 2023, the government of Mizoram took a call to sell out that particular land.
Baliganj.
And an e-tender was floated sometime in the month of July 2023. I'll come to that. And thereafter, my lord, the tender process was going on. In the meantime, on 6th of October 2023, then agreement for sale was executed, an unregistered agreement for sale with one of the officers of the government of Mizoram who was stationed in Calcutta, that is Joint Resident Commissioner, and the intending buyer who was selected as the highest bidder. That was on 6th of October 2023. Immediately thereafter, my lord, the news spread like a wildfire in Mizoram. And there were a wide-scale resentment, agitation, but nothing could be done, or at that time the government did not feel it proper to go ahead and cancel the particular agreement. In the meantime, the elections were announced.
This agreement was entered into pursuant to private negotiation.
No, my lord.
E-tender.
E-tender.
Oh, highest bidder.
Yes, my lord.
Yes.
And thereafter, what happened? In the month of October 2023, elections were announced. So there was a model code of conduct in force. So nothing could be done. Immediately after the elections were over, this issue came up again, and it was a burning issue at that particular time. The new government was sworn in on 8th of December 2023. And there were representations filed by the Calcutta Mizo Association, filed by the Calcutta Mizo Students Union, and in Aizawl also, that is the capital of Mizoram, there was agitation and several rounds of discussions were held with the new government and the new chief minister. Thereafter, the government had to take a call in public interest, my lord, to cancel that particular agreement for sale, an unregistered agreement for sale, on 4th of January 2024. And the entire money which was paid against the proposed sale of that particular land in Mizoram was returned to the buyer in one go.
With interest or without interest?
Lordship?
With interest or without interest?
No, my lords, without interest. The entire money was returned. Thereafter, my lord, the buyer...
They accepted it.
No, they accepted because it was transferred by way of bank transfer.
Bank transfer.
And they accepted on protest, of course. And a writ petition was filed before this Honorable High Court in the single bench. And that was heard and disposed of on 2nd of April 2024 with a direction that the land should be registered in favor of the writ petitioner and possession be handed over. And my lords, the writ petition was heard without calling for any affidavits. Without calling for any affidavits. And finally disposed of without giving an opportunity to file the affidavits. If I may be permitted to come to the stay application. Just for your lordship's eyes. Some of the photographs.
Last weekend, Justice Bhuiya was in Calcutta. Did you know that?
When?
Saturday, I think. There was this Tax Lawyers Federation annual meet. I met him.
Oh, I was not aware. I was not aware. Oh, he was here only for a day.
One night, yes.
One night. He left on Sunday. Yes. So that is why I think he did not inform me also. Get a copy. My lords, page 7, 8 and 9 of my stay application, my lord. Others will kindly make a note that the agreement was unregistered.
Yes.
I'll come to that issue later on. Others will come to page 7, paragraph 5.
Yes.
Your applicant state that on or about 26th May 2023.
Sorry, so the order impugned in this appeal is the 2nd April 24
2nd
order.
April 2024.
Very well.
That on or about 26th May 2023, the respondent number 2 floated an e-tender cum e-auction notice by number so and so for selling land situated at 24 Ashutosh Chaudhary Avenue, Kolkata 19. After initial deferment, the e-auction eventually held, wherein the respondent number 1 was the highest bidder. An unregistered agreement for sale was executed on 6th of October 2023 by the Joint Resident Commissioner, Mizoram House, Kolkata.
No, the e-tender was floated by respondent number 2.
Respondent number 2, my lords.
Respondent number 2 is Binod Kumar Khandelwal.
No, respondent number 2 in the writ petition.
Oh, I see. I see. Very well.
This should have been mentioned. On behalf of the General Administration Department, Government of Mizoram, being authority, seller, and Mr. Binod Kumar Khandelwal, on behalf of Excel Wincom Private Limited, being the allottee buyer. The people of the state at large came to know about this particular agreement for sale of this very old government land, being the property of the state of Mizoram since 1973, immediately after the execution of the said agreement for sale on 6th of October 2023. As such, there was a deep public resentment in the entire state, following which several NGOs, civil society members, and various social organizations raised their protests on the issue of this land, but to no heed of the state government at that particular time, which I just now mentioned, my lord. In the meantime, general elections were announced in the state in the month of October 2023 itself, and the model code of conduct came into force. And elections were held on 7 November 2023. The new government thereafter was sworn in on 8th of December 2023. The issue pertaining to the sale of land in Baliganj, Kolkata, belonging to the government of Mizoram was again raised by the NGOs, churches, student bodies, and civil society members. And locally there were representations and protests pertaining to the said sale before the new government. Because at that time, my lord, 8 December, the government took over charge. And the cancellation of the agreement was done on 4th of January 2024. So, my lord, there was practically no time because the agreement was executed, I would rather say signed, on 6th of October. Model code of conduct came into force. Election was going on. And thereafter, the new government was sworn in on 8th of December. In the meantime, representations were submitted on 22nd December 2023 by Kolkata Mizo students, an organization of the students of Mizoram in Kolkata, to the Chief Minister of Mizoram, expressing their strong objections pertaining to the process of the sale, pertaining to the process of selling of the entire premises of the land belonging to the government of Mizoram at Baliganj, which they strongly believe has a historical and heritage significance and also stand as a foundation of cultural representation, which has served as a refuge to the Mizo students, professionals residing in Kolkata, having deep significance, sentimental values and emotions for the close-knit Mizo community, which the student believe is against larger public interest. The state is a very small state, as your lordship is aware. It is situated in the far northeast region of our country. The population is, now it is approximately 12 lakhs.
Really?
Yes, my lord. Entire state. It has 40 assembly seats, one in Lok Sabha and one in Rajya Sabha. This is the composition. So, and the constituencies, assembly constituencies, my lord, they have voters which we have in our Calcutta corporation, 30,000, 35,000. And the elections are really held in a way which is not held anywhere in India. All the political parties, I'm off the track, my lord. All the political parties, they have their candidates. They erect one particular stage. And the main candidates are requested to come up in the stage. The people of the entire area, they gather. And each of the candidates, they deliver their speech. And the voters thereafter put their questions before the candidates. And you will never see any hoardings, posters, or auto rickshaws moving around with microphone, nothing like that. Because the church controls the entire system there. It's very interesting, my lord.
Very peaceful.
Very peaceful still. So, Obviously, that being the only Mizoram house which was constructed when Mizoram was a union territory, even before it became a state. It became a state in the year 1986. And this land was purchased in 73, and the house was constructed in the year 1975. So it was a union territory at that particular time. So they had a very extreme sentimental value, and they regard this as a very own property. They have some personal attachments. So that is why the entire Mizo community, which is a very close-knit community, they got agitated, and the government had no other option but to cancel it. Now, my lords, a copy of the said representation is annexed and marked as Annexure A2, page 186 to 189. My lords, if your lordship, if I can take your lordships to page 186 to 189. My lords have got it? Page 186.
Yes, 186.
This is the Kolkata Mizo students. This letter had been addressed to the Honorable Chief Minister, dated 22nd of December 2023. The government took over charge on.
Yes.
The government took charge on 8th of December 2023, and this letter is 22nd December 2023. Prayer for retrieval of Baliganj Mizoram House. Respected sir, greetings on behalf of the Kolkata Mizo students. Baliganj Mizoram House, Kolkata has served as a refuge for the Mizo students, families and professionals residing in Kolkata. The premises deeply hold significant sentimental values and emotions for the close-knit Mizo community. Sadly, it has been learned that the process of selling of the entire premises is in its final stage. However, we, the Kolkata Mizo students, believe that the selling off of the plot in Baliganj is against larger public interest. However, moreover, it has a historical and heritage significance within the periphery of central Kolkata, and it also stands as a foundation of cultural representation. We hope you will intervene, settle the issue, and act accordingly so that these merits of ours remain intact. So in Kolkata, they have a Kolkata Mizo Student Association, and they also have a Mizoram peoples, that is Mizo. They have a Mizo organization, Calcutta Mizo Welfare Organization.
Welfare Association.
Welfare Association. Thereafter, my lords, paragraph 6, page 9.
Yes.
Your applicants state that another representation dated 27 December 2023 was submitted to the Chief Minister of Mizoram on behalf of another important social organization of the Mizoram, being the Calcutta Mizo Welfare Association, with a prayer therein to cancel the process of the execution of the sale of the land belonging to the Mizoram at Baliganj, Kolkata, due to the reason of larger public interest, as the connection between the people of Mizoram and this land goes a long way, as it has served as a refuge for comfort for generation of Mizos traveling across the country, and the sentimental attachment this land holds in the hearts of the people. The Calcutta Mizo Welfare Association had further pointed out in the said representation that efforts have been made to persuade the government not to sell the land in various ways, but to no avail, which I mentioned just now, my lord, during the time of the previous government. There were efforts on the part of the people of Mizoram that please do not sell this land, but at that time the government did not give any heed to that. A copy of the said representation is annexed herewith and marked Annexure 3, page 190, my lord. Annexure A3, my lord, page 190. Greetings on behalf of the Calcutta Mizo Welfare Association. As you are aware, the process of selling of land belonging to Government of Mizoram at Baliganj, Kolkata is going on. And upon inquiring, we have learned that the process had not reached its final stage. As such, we would like to kindly draw your attention regarding our prayer to cancel the entire process on behalf of the Mizo community here in Kolkata. It may be noted that from the outset of the intent to sell the land, it greatly saddened the hearts of the Mizo community, not only here in Kolkata, but Mizos as a whole. The connection between the people and this land goes a long way, as it had served as a refuge for comfort for generation of Mizos traveling across the country. Many things can be said at length regarding the sentimental attachment this land holds in the hearts of the people. Hence, effort have been made to persuade the government not to sell the land in various ways, but to no avail. With the formation of a new government, your government, our hopes have greatly renewed. The Welfare Executive Committee, after closely studying the situation at hand, believes that there is still a ground for cancellation of the process of selling of Baliganj land, as it has not reached its final stage. As your government strive to stand for the people, we the people, the Calcutta Mizo Welfare Association, request you to cancel the entire process of selling of the land at all cost. We hope and pray that this request will materialize in your hand. So this was the representation which was submitted by the Calcutta Mizo Welfare Association. Thereafter, my lords, the e-tender, I'll just quickly take your lordship, e-tender page 64 of the stay application. My lords will kindly come to page 67. That is the schedule for the e-tender come e-auction. Tender publishing date was 10th of July. And the entire schedule was given. Now here, my lords, if I can take your lordships to some of the clauses of this particular e-tender come e-auction. Page 71. Clause 3.1.11. Page 71. .1.11. The authority reserves right to cancel the e-tender come e-auction process at any stage prior to the signing of the sale deed. So sale deed was not executed, my lord.
Agreement was said.
Sale agreement, an unregistered sale agreement was signed. So it is very specific here, at any stage prior to the signing of the sale deed, the amount deposited till such date by the allottee, including the EMD, shall be returned, which has been returned in full, in one stroke. The authority shall not be liable to pay any compensation or interest for any loss that they may have incurred due to such cancellation. So this is clause 3.1.11, one of the clauses on the basis of which this tender was cancelled in public interest. Thereafter, my lords, page 85, clause 5.5. This is regarding issuance of LOI and LOA. Issuance of LOI and LOA shall not give the right to the successful bidder to have the ownership of the property. So far as the ownership is concerned, that is very specifically made clear in this particular clause, that the issuance of the letter of acceptance will not be a ground to consider that the ownership of the property has been transferred. Because first of all, there was no sale deed, no deed of conveyance being registered, only an unregistered agreement for sale. Secondly, my lord, the clause 3.1.11, on the basis of which the government reserved the right to cancel. So that was there. And thereafter, my lords, 5.5 at page 85, which says that issuance of LOA shall not give the right to the successful bidder to have the ownership of the property. Page 85, my lords.
Yes, yes, seen that.
Thereafter, my lord, on the same page, paragraph 6, clause 6, I'm sorry, clause 6, execution of sale deed. So regarding the execution of sale deed, there was a separate clause, my lord. And the respondents were fully aware about all these clauses which were there in the e-tender cum e-auction terms and conditions before signing it and before signing the agreement for sale. Ownership, I'll take your lordship straight to clause 6.2. Same page, my lord.
Yes, yes.
Same page. The ownership and the possession of the property will be transferred only after execution of the sale deed. So the question of ownership being transferred does not arise. The owner,
in effect, Mr. Dev, they obtained a decree for specific performance.
Absolutely,
before
because there was an arbitration clause also in here. I'll come to that also. So the ownership was
yes.
And in fact, writ of mandamus was issued without calling for affidavits also. It was in
My brother is suggesting mediation.
arbitration is there.
So, this is
Alternative remedy is there.
ARP-MET. This is now the regime of ARP-MET. In the process of making arbitration, you can also mediate. That is the
alternative remedy is always there.
Yes, you can.
So ownership, my lord, has never been transferred.
On the consent of both the parties.
Correct. It has never been transferred. Cannot, without a conveyance.
Without a conveyance, it cannot be. So 6.2 is very clear, my lord. And what I was most respectfully submitting before your lordships, that they were very much aware, the respondents were very much aware of these terms and conditions before signing the agreement for sale. My lords, if I can take your lordships again back to page 10 of the stay application. This is very important, my lord. Paragraph 7. Your, shall I proceed? Your applicant states that the new government considered all the representations, including interest to the common people of the state in Aizawl, being the capital of Mizoram. Since the new government took over responsibility on 8th of December 2023, it decided to revisit the issue for ascertaining the propriety of the decision and process undertaken for putting the land in question on sale. Several anomalies surfaced apropos the decision-making process, as it was opposed to larger public interest. The government of Mizoram therefore took a call in larger public interest to cancel the entire e-tender cum e-auction and the process of sale on 4th of January 2024, after considering all relevant factors. The disposal of the government land at that particular juncture shall be against the general interest of the public. As such, the government of Mizoram, in exercise of its power provided under clause 3.1.11 with clause 5.5 and 6.2 of the bid document, cancel the bid process in larger interest of the public, and the entire money already paid by the respondent writ petitioners, including the earnest money paid, was refunded. To quell doubts, if any, the applicants most respectfully submits that the change of the government was not at all a reason for cancellation of the sale process. This issue came up, that whether it was for political consideration or not. That was not at all the consideration, because it was in larger public interest that the government was compelled to take a call.
So before cancellation, they are informed that we are going to cancel.
Lordship,
If before cancelling,
yes, a letter was issued, and thereafter the amount was refunded.
Just as a matter of interest, the consideration amount was agreed at how much?
38.5 crores approximately. 36 crores. And the area is 26 kata. And that also in a prime location in Paliganj. To quell doubts, if any, the applicants most respectfully submits that the change of government was not at all a reason for cancellation of the sale process. In fact, it was a burning issue in the state and also strongly raised by the common people before the erstwhile government, from the time when the people came to know about the proposed sale of land after the execution of the agreement for sale on 6th October 2023, because the matter came to light and everybody came to know about it only after the sale was executed. And yet the same remain unattended and unheeded. It may be mentioned herein that Mizoram is a very small state located in the remote northeastern part of our country. The state neither has any multi-speciality hospital nor any super specialty hospital for treatment of patients for serious ailments, including cancer. The other two houses belonging to the government of Mizoram in Kolkata, being the Salt Lake Mizoram House and Newtown Mizoram House, are overcrowded with officials and with patients. A plan for construction of G+3 building in this 26 quotas of land belonging to the government of Mizoram had already been sanctioned by the Kolkata Municipal Corporation on 25th of August 2022, being building permit number so and so, dated 25th August 2022, being valid for 5 years. It is valid till 2027, my lord. So here I pause for a moment, my lord, and if I can take your lordships to the order dated 16th of May, passed by this honorable court.
January 24. অনেক আগে কি টেন্ডারের অনেক আগে তো বিজলি ঠিক ঠিক করেছে বিজলি
দুটো আছে মনে হয়, একটা দিয়ে দেবেন তো আমাকে। While এটা আছে আপনাদের কাছে। While admitting this appeal,
Yes.
While admitting this appeal, my lords, and while an interim stay on the learned single judge's order was passed by this Honorable Court Division Bench, my lord will kindly come to page 2. An observation. Paragraph 6. Since the positive direction has been issued for registration of the deed of conveyance, and also taking note of the undisputed fact that the sale consideration which was deposited by the writ petitioner has been returned in full to the writ petitioner, and also taking note of the stand taken by the appellant, which has been recorded by the learned single bench in paragraph 38 of the impugned judgment, that a plan for construction of G+3 building on 26 kathas of the land in question has already been sanctioned by the Kolkata Municipal Corporation on August 25, 2022, which is valid for 5 years. There will be an interim order of stay of the direction issued by the learned single bench in the impugned order. The learned senior advocate appearing for the respondent writ petitioner submitted that taking advantage of the stay, the appellant should not dispose of the property. In our view, this apprehension may not prima facie be right, more particularly when the state of Mizoram has taken a decision that it has planned to utilize the land for construction of a building consisting of G+3 floors, and building approvals have already been obtained. So, my lord, already a plan was there. The plan was sanctioned in the year 2022, valid for 5 years, which will expire in the year 2027, August. So, the fact remains, my lord, what has happened? The state doesn't have any hospital, good hospital. There's only one civil hospital. Some private nursing homes are there, of course, and doctors, they go from Kolkata, they go from Chennai. Local doctors are also there. But for specialized treatment, the patients are referred to Calcutta, because Calcutta is the nearest location. It's 55 minutes by flight.
25 minutes.
55.
Direct flights are there.
Direct flight every day.
One or more than one?
One, and one from Aizawl to Kolkata, Aizawl to Delhi, one Aizawl to Guwahati, one Aizawl to Shillong. In fact, Delhi has got 2 flights a day on Fridays and Sundays. So now it is well connected. But the closest place is Kolkata.
And only Aizawl has airport.
Only Aizawl has airport. Other districts are connected with helicopters or by road. In monsoon, it is very difficult because the road conditions become bad in the hilly terrain. That difficulty is there. So, my lord, what happens? The patients are referred to Calcutta mainly. And obviously, most of them are very poor, my lord. They cannot afford to stay in hotels and other places. So they basically take shelter in the
Mizoram
house. Now both Salt Lake and Newtown is overcrowded. So that is why there is a pressing demand that this particular land after construction should be allocated specifically for the patients, so that the patients can come and stay here at a very low cost.
These decisions will be reflected in the records. Decision of the government.
Decisions of the government is not there, but the representations are there. A plan is already there.
Plan we have seen. It's annexed here.
Plan is here. The sanction plan is here.
So there is 1:15 now.
My lord.
Second half, this bench is not
I know, I
available.
know.
So when shall we keep it? Tell us.
Monday.
May not be possible. Dao, তুমি খোলো দেখো খাতাটা।
My lord,
You understand?
take up continuation of the
Other matters have been fixed already.
my lord, Tuesday.
Thursday.
Then will it be possible, my lord?
Thursday or Friday?
No, Friday I'm traveling.
Then either Thursday or then otherwise Monday week পরেরটা।
Thursday করে দিন।
Thursday?
Thursday.
Same time?
Same time. Thursday is
20th.
20th. My lord.
হবে তো?
A little early if possible, my lord.
12:15. 1 hour, you should finish.
I should be able to complete. I'm deeply obliged.
Mr. Deb, Learned Advocate General for the state of Mizoram, begins his argument on behalf of the appellants, but does not conclude. Paragraph. List this matter once again on কবে বললাম? 20. Marked 12:15 p.m.
My lord, I filed the supplementary affidavit. Kindly, my lord, take it. My lord, the supplementary affidavit may it be recorded that it has been.
তার নিচে লিখে দাও। This you filed before the learned single judge.
Yes, I'm disclosing the
A
affidavit. which was
copy
there.
of the supplementary affidavit filed by the writ petitioners before the learned single judge, comma, a copy, na copies called, filed in court today, comma, be kept with the records.
My lords, one humble submission, my lords. On the last day, my lords, your lordship had disposed of the stay application, but there was an interim stay.
That continues.
That has not been mentioned, my lord. It has not been reflected in the order.
That nobody
Yes,
will
of course, my
dispute.
lord. Whatever
Nobody.
was continuing, that should continue.
Since we disposed of the stay application on the last occasion, comma, we clarify that the interim stay order granted by a coordinate bench on
16th
May 2024,
2024, comma, shall continue till the disposal of the appeal.
Grateful.
I'm deeply obliged, my lord. Affidavit in opposition, our reply to the opposition may be taken
Filed before us. Filed affidavit in reply filed on behalf of the appellants in response to the affidavit in opposition filed by the writ petitioners be kept with the records.
Grateful, my lord.
I was telling Mr. Mitru, I have forgotten even the name of the matter.
No, that is because possibly
Mr. S.N. Mukherjee had argued. You did not argue, Mr. Dotto.
তো এই
Or did you?
ক্ষেত্রে আমি আরো করিনি এই ছন্দমূল কোর্টে এটা করিনি then I have to prepare myself because one free India Millard I had assisted your lordship this bench in court number 6.
Yes, we heard in court number 6 only.
Yes.
We have read the argument that has been prepared by the state. The thing is this argument was not advanced, but in the written house of argument, they have taken the point.
This
So
state.
yes. Now their only point, Mr. Mitro, possibly they will be arguing, maybe in the different way, but what has been taken in the written house of argument, what is troubling us, you got the property from Mitros. Mitros means the
Yes, yes.
Now that was by of a lease. That was by of a lease. Lease was for 50 years. Now by operation of the Estate Acquisition Act, you will have the same right as the original lessor had. So your lease term expires after 50 years.
I shall make my submissions, my lord, late.
So that is the point they have taken.
Yes, I shall address to that.
That is the only point they have taken in the written argument. Of course, we'll hear Mr. Dotto once again. But what is your response to that?
I shall respond to that, my lord.
Because your lease expired after 50 years. Then how can you claim compensation?
I'll respond to that, my lord. I have answered, my lord. I will respond to that.
And another 2-3 issues, whether the land in question, that was an agricultural land or non-agricultural land. Because it depends on
Recorded.
the-
It's again recorded. I shall show.
Yes, that's why on last occasion I wanted to see the record. In the record of right, it appears that it's recorded as non-agricultural land.
Yes.
So if it is the non-agricultural land, the lessor had no possession. So the lessor could not have retained the land. Then how can you get your name recorded as Rayat? How Bhaggolokki got his name recorded as Rayat? At best, it could have been a lessee.
I will.
By operation of law, you don't become Rayat because it was a non-agricultural tenancy land. So this is the point they have taken in the written notice of argument. So therefore, they are saying that on earlier 2 occasions, mistakenly have given you, you are the lessee. We treated you Rayat incorrectly. The same mistake we cannot commit again. And maybe they may say that it is by operation of law only. By operation of section 5, it happened because since it's operation of law, there is no question of estoppel. These are the things.
So the state stand is crystallized now in the written notes of argument. But if you want to make submission, of course, we'll hear you. But we want to really now get over with this matter. Long pending for a very long time.
Yes, yes.
So, Mr. Dotto, to refresh your memory, there was a large chunk of land. One portion of the land was acquired under land acquisition, compensation paid. Second part, acquired, compensation paid. When the third part also acquisition proceedings initiated, but when it came to the stage of paying compensation, then suddenly they issue a notice on the section 6(3) of the estate acquisition for resumption. Now the resumption got set aside by the tribunal. You challenge it unsuccessfully for the High Court. Now their simple case is this: resumption has gone, so therefore it's my land. On earlier occasion you gave me compensation. In this matter also you initiated compensation. Kindly complete the proceedings by giving compensation in terms of the new Act, 2013 Act. This is the simple case.
Under the new Act, yes.
Under the new Act.
That's the law.
This is their case. And your case is this: you trace the history from the back, maybe rightly, that look, you are not the Rayat. You are the lessee, having a right to use it for 50 years only. The 50 years expired long ago. But in the record of rights, after the Estate Acquisition Act, in the arrest record, their name is appearing as Rayat. You have treated them as Rayat. You have accepted tax for decades. So it's not a mere mistake. And you also treating him as a Rayat gave compensation twice. So why at this stage you can again go back to your earlier position?
Khaznas were accepted. The tax were accepted.
So we have expressed our mind that so that you have understood the case of the both sides, and so that we can argue elaborately and conclude the hearing and decide it accordingly.
When? Let us please fix the date now and just get over with it.
True.
But keep it on any Friday, maybe early next month.
দেখো খাতাটা খোলো 5th December ও না তুই কবে দিবি ও তাহলে তো ঠিকই আছে the end of this month ঠিক আছে এটা আছে ঠিক আছে আবার একটু বাইরে পারো 12th December Mr. 12th December 2 o'clock so at least 1.5 hours we'll get if not 2.5 hours but they will say
নাম্বারগুলো ঠিক আছে আমি আগে
for Saraswati Press.
Huh?
For Saraswati Press, my lord.
Not necessary, perhaps. States. Dekho. Let these matters, by consent of learned advocates for the parties, let these matters be listed again on December 12th at 2 p.m. under the same heading.
Item 5. Take 7. Five.
এই 8 নম্বর এটা দিন 8 নম্বরটা দিন 8
নম্বরটা
হ্যাঁ
Mr. Ghosh, yes, there's a bunch of matters.
On the last occasion, I made my submissions. I have also prepared a written notes for argument, but one point is missing, which I found in the last my exercise, because one question was raised by your lordship and also the learned honorable single judge, regarding the vesting of the public street. Then it was said that vesting, my lord, maybe there is a fixed connotation. The word vesting in a particular judgment is said there is a fixed connotation, but vesting maybe in title, vesting in possession, or for any limited purpose. That was just I'm pointing out some of the paragraphs of the judgment, and then also the petitions. Your lordship come to the judgment first, because there are the two issues are here. One, my lord, regarding the display of advertisement. So far as that aspect is concerned, your court, my lord, accepted our point that the display of advertisement cannot be done without obtaining permission and license from the Kolkata Municipal Corporation. And there is another issue, that display of advertisement on the flyover. And we had a claim, my lord, that land utilization charges. There are two aspects of the matter. First, my lord, whether the display of advertisement has been obtained on permission from Kolkata Municipal Corporation or not. If, my lord, that permission is not granted, then the advertisement cannot be put in the flyover. And if the flyover, if the advertisement is put in the flyover after obtaining the permission, then that question may arise whether the land use charges could be charged by us or not, or what is the situation on that? What is the law on that? If you logically come to Paragraph 13 of the judgment. Judgment under article. Paragraph 39.
39 or 13?
39. However, as HRBC is not empowered under the law to allow advertisement but only to rent out the sites for such purposes, HRBC, by inserting clause 12 in terms of the conditions of the contract, ensured that a successful bidder would take necessary permission and license from the KMC and also pay the advertisement taxes to the KMC as per the KMC Act. In fact, agreement they entered into by the after the tender process was completed by the Howrah River Commissioner. Then there is a specific clause that is also quoted here. The specific clause, my lord, that permission has to be obtained, otherwise, my lord, the no display of advertisement. But in the tender document, I show to your lordship, even the honorable judge, my lord, coming to that conclusion, did not restrain that whether the permission could not be produced. He, my lord, issued the demand certain, my lord, the under certain section, but that is not the permission because even if an unauthorized, my lord, the display of advertisement is made, that we may raise a demand. But because of unauthorized use of the particular site or display of the advertisement, permission may not be granted if asked for. That is the law, but it is well decided and also the provision. Now, if you looks at the petition, what the Howrah River Commission has done, sorry. At page 73, tender document, and the right shall be provided to the 72. 71 pass, remember? Tender document, page 71. Tender document for display of holdings and kiosks on different structures under the control of HRBC. Doesn't such. Then you logically come to after the tender process was completed. At page 107, one of the letter I'm showing my lord. Therefore, the advertisement right for display of hoarding and kiosk of Vidyasagar Setu has been given to the parties. So when such a right has been given, although having no power under the Hooghly River the Commission Act, then my lord, this writing giving the power to any party, site maybe that I'll come to my lord, that act itself, my lord, the power of the commissioner. Then my lord, that site cannot be provided. And the honorable judge has come to the conclusion that has to, my lord, comply with the relevant provisions. If the lordship now seek the village see of the corporation knows about that. That the site for the license has to be obtained for the display of the advertisement. So my response sufficient, my lord, if that right cannot be given by the Howrah River Commissioner and the parties do not ask for the permission from us on payment of that charges under that particular section, then my lord, automatically they're going to put up any hoarding wherever it is. Therefore, the grant of my lord, permission or rent out any site under control of the Howrah River Commissioner, a flyover I see, that the power of control management is with the Howrah River Commissioner. Then, my lord, without having that license, the site, my lord, the renting out by a tender process is one as for the matter. But in order to put up the advertisement, the permission is. If the permission is not there, today as a because my lord, otherwise, my lord, only on the issue, deciding the issue, the land utility charges. I'm taking it for a moment, it may go against me. But that cannot automatically say that they can put up the hoarding. So today, my lord, still, my lord, they are displaying the advertisement on those. My lord. So when the matter is coming to the court, my lord, they're looking at the situation. The court will pass a definite order. When the court on the single bench had arrived at findings, and there is no document to show that the permission had been obtained, the first thing, it should have been stopped. And if the advertisement does not come, then there is no question of consideration, LUC would be required or not. That would come on a later stage after obtaining the permission. I may grant permission, may not grant permission. Therefore, your lordship will look at in respect of this matter, and your lordship looks at the agreement clause 1 clause that is quoted in the judgment also at page 77. After my lord, for the question, the selected agents, paragraph 12. The selected agency shall obtain necessary permission from the municipal commissioner after paying tax, fees, and charges before display of the advertisement. Which is within the jurisdiction of the corporation by any means upon HRBC properties. This is the statutory provision, the extract of the Calcutta Corporation 1980, chapter 7 in the tender document for ready reference. Therefore, the tender document is also incorporated. But they never approached to us for obtaining the permission on the what is the on the plus 5. And my lord, this is my lord, I am first submitting my lord when the court finding is there on that issue. At the outset, they have to stop my lord, the putting up the hoardings. Now you logically come to
taxes have to be paid to the corporation. Taxes to Calcutta Howrah Municipal Corporation license.
Have you filed any note, Mr. Basu? No.
Not yet, my lord.
Better you all file notes, make very short oral submission,
point is very
so that we can dispose of long pending for very.
That's right. When I also prepared the note, but one thing.
Give me a copy.
That was only one aspect of matter.
This is not the issue in the proceeding.
No.
Issue is land utility charges can be charged or not.
No. That is the. That was one of the issues. They will also look at the judgment also fine. I raised this issue.
Raised to the other issues which is not there.
Otherwise,
nobody can bust that.
Otherwise, the court would not have come to that conclusion.
Who appeared? Mr. Shubroto Banerjee appeared for HRBC.
Yes.
Yes. Have you filed any note?
No.
You also filed your written note. Short written note.
Very short.
Yes.
Hello, one thing, well, Lordship put a question also regarding the vesting, the court also discussed here upon referring to section 333, 334, 433 and 434. Regarding the vesting, that court will explain that it may be for a limited purpose for maintaining control of the public streets. But I submitted, my lord, it is vesting really entitled. But I, my lord, on my examination, then you also asked me the provision, the chapter. Of course, my lord, then present the act. It does not say, that is the reason why you logically. 343 section says that vesting of public streets, squares, parks, gardens in the Kolkata Municipal Corporation. Then it says what is the provision, and then the function of the municipal commission in respect of the building, in respect of public streets. Court upon considering these two provisions, they observe that these provisions regarding the vesting of the public streets, not in title but for limited purpose. But I am submitting to Lordship, my lord, I have inquired and have filed the Kolkata Municipal Corporation of 1951. That says the streets and public places well, it says that you should top of the what is well, it is a street. Then you can see the proprietary rights. Proprietary rights of the corporation. Therefore, what is vested in the corporation under this chapter, the corporation acquires the proprietary rights over that.
Bridge is not mentioned.
Hello?
Bridge is not mentioned. Overbridge is not mentioned. Overbridge is not mentioned.
It has been mentioned here. The said that in the provisions. But the chapter starts with the words that the proprietary rights of the corporation.
But what will vest? All public streets, squares.
Whatever vesting is made under this chapter. Whatever vests in the corporation under this chapter, the corporation acquires the proprietary rights over that.
Including soil, subsoil, streets, squares, all erections. All erections.
I'm giving the another thing, water supply, subsoil, every right, proprietary rights. You know, this is Malad. Everything is vested in the corporate as a proprietary rights. Although these words, as found in the Calcutta Municipal Act 1951, is not here.
What it is appertaining there to money, appertaining to a water body that all public tanks, reservoirs, cisterns, wells, tube wells, aqueducts, conduits, tunnels, pipes, taps, other water works, whether made, laid, or fitted at the cost of the municipal fund or otherwise, and all bridges, buildings, etc., appertaining thereto. এটা তুমি জিনিসটা ফ্লাইওভার যেটা হচ্ছে জলের সাথে সম্পর্ক
the property rights words under that those two different chapters are of course, my lord, not my lord, stated in the present Kolkata Municipal Corporation 1980. But if your lordship looks at repeal and savings 635B, it says all properties movable or immovable, all rights of whatever kind, used, enjoyed, or possessed by, and all interest whatever kind, owned by or vested in the Corporation of Kolkata as constituted under the Calcutta Municipal Act 1951 shall at the commencement of this act be deemed to be owned by or vested in the corporation as constituted under this act. So my submission would be, my lord, that once the property right is vested, it is not required even to incorporate all the amendment which comes, amended act comes later on, that right is existing. It's not required. Therefore, the right, vested right is, my lord, implies, well, so far as we are concerned, that property rights will be. Now, the second question, my lord, that that was not incorporated because I, my lord, made that exercise later on to find out because the other, on the long before when the matter was heard, that certain questions were put by your lordship, then I made that exercise and found that this is the position. Now, your lordship, my lord, put a question regarding that the land use charges, that is, my lord, the how we charges. Well, I'm submitting, my lord, the word land use charges, a nomenclature may be a different one, but what I say, the land use charges in a way is a rent for permitting someone to use the land. Now that question is, my lord, the whether that property, if I have the property right, if I give it, whether I can, my lord, charge a rent or, my lord, charges. If you look at the section, (539), you're going to look at 539 of the KMC Act. It says, well, disposal of the property. I rely on, well, the clause there are certain provisions, well, under what conditions, well, the disposal of the property could be made. Clause C, 539, clause C says, in case not covered by clause A or clause B, the municipal commissioner may, with the sanction of the corporation, lease, sell, let out, on hire, or otherwise transfer any property movable or immovable belonging to the Kolkata Municipal Corporation. Well, that is the power we have derived to charge for the LUC. And that has been incorporated in the Malati budget estimate, what should be the rate of that amount. The HRBC Act never says that they can, my lord, allow anyone to display the advertisement or to charge the land user. They say we have given on rent particular site.
This flyover, the structure,
My lord.
that belongs to whom?
The flyover structure is managed and controlled. It's a government, because he has been permitted to. If a lawsuit looks at their affidavit, it is clear. And under the act also, they are under managed and controlled. I on the last occasion will place the Howrah Rivers Beach Commission Act that says they are to manage and control.
They are not the owner of the structure.
Not the of the structure. And if they control it, but they can, I say, the site, they can rent out. But for the purpose of, because the site, you will also see that the bridge has been, flyover has been erected on the land or the street of the Kolkata Municipal Corporation. And that too with the discussion with the state government. If you lost, well, their affidavit, the supplementary affidavit, that was not incorporated by a petition. supplementary paper book. They never say that we are the owner of the bridge. HRBC constructed and maintains different flyovers and the bridges with the statutory authority to control all those flyover and bridges which are vested on HRBC. Vesting the word when I use in a particular section, that vested the bridge vested for the purpose of this is well vesting in limited for limited purpose to manage and control. I read the provincial lordship given Malord the Howrah River Beach, Hooghly River Beach Act 19 Malord.
Yes, you have answered.
And people lordship looks at just I'm pointing out.
Mr. Ghosh, this thing issue was addressed by the learned single judge.
Yes, sir.
What was the view of the learned single judge on this argument?
Learned the roundable single bench Malord said that corporation is not the owner and faced for a limited purpose, which refers to 343 and 344.
Yes.
Limited purpose and court intend to say that I only can maintain lay down street all these things. Therefore, I have no authority. That authority is with the HRBC, but I am disputing about that fact. That cannot be, my lord. Law also does not say that. Neither the HRB Act or the Kolkata Municipal Corporation that street could be vested to the HRBC. Purpose of the act, my lord.
Who is the owner of this park and all this? Parks, squares, bridges, who are the owners?
We have become the owner.
State government is not owner.
No. All vested to the Kolkata Municipal Corporation, except that there is been mentioned in 343. Some of the properties are there which belongs to the KMDA or some other statutory authorities. That is provided under the act long before.
In the KMC records, these, for example, Maddox Square, Ritchie Park,
My lord.
would it, in the records, would that indicate any owner of the?
If on that basis, we exercise the power as the owner. On the basis of that provision, vesting, proprietary, we exercise. Otherwise, my lord, nobody could come regarding the permission for fest, exhibition or something like that.
You may be in control management, as the learned judge has said.
That is not a control. If the right is not with me, control is one thing, and one of the right to the extent of the other for other.
Can you sell this?
Suppose you can see that sometime we have to dispose of certain streets for closing for the purpose of definite purpose of with payment, transfer. Otherwise, I cannot do it unless one of the only that power is with me. Even in the streets, that the certain streets and other things are to be given on lease to some other persons. Of course, that is to be approved by the house.
Can you sell a portion of the street? Can you sell?
No, because it is, I do not sell it because of the reasons it is with me as the public trust, that for the benefit of the public. Therefore, I do not sell the street, which is, my lord, already created. The street has been created. Street I will not sell.
Whether you will or not is another question.
I may have, but I cannot, having regard to the provision of the Act, I cannot, because I am in trust with the property right, because it is mainly for the public. That benefit I cannot cut, because not only the existing road streets I'm to control or something like that, I'm to create also the street depending on the necessity requirement.
In the land record, who is recorded as owner?
Hello?
In the land record,
Land record does not maintain the Kolkata Municipal Corporation. So where this is concerned. Well, otherwise, whatever the property is vested in me under the Act, I cannot deal with only because of that manage and control. And that is the reason the 513 is there, that dispose of the property in various modes. In fact, my lord, with that power, we will be in difficulty to run or something like that.
KMC Act আছে?
একটাই দিয়ে আপনার সাথে ওটা এই যে compensation will be paid for damage. Such compensation for any damage to any property of the corporation. আমার property না থাকলে আমার provision থাকবে।
কোন ক্যাপিটাল আছে?
Payment
না রাইট আছে কিনা তার তো রাইটের উপর ব্যাপার। পাচ্ছেন না? আছে
এ তো হবে না রুলস
rules না, no, act. Vesting for different purpose, vesting for different purpose. The HRBC Malad Act, the Honorable US Commissioner, in paragraph 2, in the supplementary paper book, their opposition is there. My lord, got it, my lord, supplementary paper book is there.
HRBC Act is here.
No, Act, my lord, the authority, my lord, the opposition to the writ petition. That was given in the supplementary paper by the petitioner. It was not included in my
Supplementary informal paper. Yes.
Legally, see, well, page 3B. HRPC was entrusted from time to time by the Transport Department, Government of West Bengal to construct and maintain, control and the flyovers and the bridges at different places like HEC Post Road, Guriat Road, such and such place. By implementing the Calcutta Transport Infrastructure Development project of the Transport Department, Government of West Bengal, funded by Japan Bank of our International Corporation, JBIC.
Mr. Ghosh, if AMC was the absolute owner.
But it's a joint venture. But in the process of
government alone couldn't have authorized.
No, government alone not. But because I am to take also sometimes permission, because for using a different purpose, for a particular purpose. Therefore, I am to take certain permission sometimes from the government. Not I cannot absolutely, but I cannot say because it is also under a particular ministry. Although, my lord, my right is there under within the framework of the KMC Act 1980, but that also provided in certain cases I am to obtain the sanction or permission from the state government.
But your argument has been dealt with the learned single judge relied upon to judgment of Supreme Court squarely on the point. 57 Supreme Court clearly says.
No, 57 Supreme Court, my lord. I have, my lord, also incorporated my written argument. That's one judgment the Supreme Court has says that there is a fixed connotation.
Yes.
That the court has said that it's for different purposes. Now I am showing that these vesting, so far as we are the concern, the vesting in title because of the act itself says so. Number one. Number two, in another judgment the court has referred to that provisions and our provisions are not identical. Language is different. That is also I pointed out in my opposition.